Item 1 you have to for I support. There was some.
Lord, I wanted to mention one matter. Two matters in which both my learned friend and myself, we are appearing for the respondents. In that case,
Not in the list.
no, it is in the list. It is in the list, Lord.
Both sides have some difficulty because my advocate on record, his wife has suffered some medical emergency, they are rushed to the middle. And so far as the status.
So Miss State is also there.
Is in some medical condition, so.
He's out of station for review of his knee.
So these two matters may be
7 and 8.
3, 7,
and 8, my lord.
and 8.
Yes, my lord.
This will be a
So
mutual
7
prayer on all the.
Yes,
Seven-
yes, Lord.
7 and 8 connected.
Yes, my lord.
3, 7 and 8.
Much obliged.
Next circuit.
Much obliged.
Lordship, I would like to mention item number electricity matter, Lordship. I have some personal difficulty where I have to rush to hospital. So can it be taken up day after tomorrow, Lordship?
Day after tomorrow.
My
Day
lord,
after tomorrow. 17, 18, 19, 20, 21.
sir, मेरा report को next year बिट देता हूँ. My lord, I.
Why not tomorrow? Why not tomorrow? Tomorrow?
Tomorrow actually festival is there. Though High Court is. But tomorrow the bar is going to take the resolution.
So then day after tomorrow.
Day after tomorrow.
Day after tomorrow it is being fixed. Learned councils.
Lordship. Oblige, Lordship.
Note it.
Oblige.
Once you have to for 104. I intimated Mr. Samantha. And to mail also. You because of my law.
No, learned council, learned council, learned
Dates
council.
are different.
Acha, in which somebody was representing through virtual mode.
Yes,
What happened?
I intimated him, he said, okay.
Neither the learned council who was representing
Yes.
physically, she is present.
He came back from Milan. Right? So, then he's joining us. He's the.
Person who is sitting at the bench. And you are representing the
Petitioner.
Oh, but you are representing the petitioner. Some of the respondents, so it is well known. Nobody,
I think the short also were calling that it's connecting. So.
yes,
In the meantime, we may come on
at
live.
this present moment, nobody is representing through virtual mode. Let it be passed over.
Yes.
When it can be taken up, on it council.
Let it short pass. Ask him to get. Item 4, you are one of the party.
My lord, I am appearing for the petition.
For the petitioner,
Yes,
for the respondent,
opposite party As because it is a civil division, so service has not been paid until and unless court passed
No,
directly.
counsel. Let it be served.
I am having the spare copy. I can serve it.
This is a case from which,
My lord, I filed a suit for
no,
recovery.
no. Port Blair, civil judge senior division, Port Blair. Impugned order is of the
Subsequently transferred to the Court of Joint Civil Justice Senior Division. Now matter is pending before the Court of Joint Civil Justice Senior Division of Port Blair.
the impugned order
Yes,
is passed by the joint civil judge senior division, Port Blair,
yes,
who sits here only.
yes.
So who was representing
Mrs. Nag, Mrs. Anjali Nag.
on
Yeah, Ramesh Nag. Junior is here.
Hmm.
I can serve the copy.
yes,
But, yes, sir.
I need to take instruction from my.
I am serving the copy. If you require time, it will be fixed. Day after tomorrow, no problem. You are appearing. फोटो में कॉपी सर्विस कर रहा हूँ तो अगर टाइम चाहिए तो पर्ची का टाइम लेना ओके
learned counsel. Hey, one minute. Please. Learned RWS signifies RWS.
Reduced section. Reduced section 150.
So you are the plaintiff owner.
Plaintiff owner.
Hmm.
They are in unauthorized occupation. This is a suit for recovery of possession. Fire up in 2011. These opposite parties entered into a lease deed with me for a resort business. And lease deed has been executed. I have given the possession, and that lease deed was valid up to 10 years. Lease period was expired. Even thereafter, they are unauthorized to occupy the land. I issued a notice also to evict because the lease period, it has not been extended further. So as because they are in unauthorizedly occupying my land even after expiry of the lease period, so I filed a suit for recovery of possession. They are in authorized occupation. Even at the time of filing of this suit, I filed an application under Order 13 Rule 1 and 2 for temporary injunction, restraining the defendants not to make any construction or repair work in my land, as because the lease period expired. Now, after receiving the summon and the show cause notice, these opposite parties filed 3 applications in a single day. 3 applications, 1 application under Order 13 Rule 7 for appointment of a local investigation commissioner, another application under Order 13 and Rule 1 and 2, and the written objection against my injunction.
Under Order 39, Rule 1 and 2, seeking
repair.
Under Order 39, Rule 1 and 2.
Yes, seeking repair. How can it possible?
Place Order 39,
Yes,
1 and 2.
that order.
It is not within my knowledge.
Yes, that order, input order, kindly see. Accordingly, the petition filed on 22/7/2002 under Order 39 Rule 1 and 2, read with Section 150 of CPC is allowed. This application was filed by the defendants, opposite party. And in that injunction application, court allowed them to repair the dilapidated resort.
So as far as I can get through the impugned order, an application seek through this impugned order, prayer for repair has been allowed. Prayer for repairing has been allowed under Order 39, Rules 1 and 2 of the Code of Civil Procedure, read with Section 151.
Yes. Order 13 Rule 1 and 2 for injunction. Even my application is pending, not to repair. My application is getting pending.
Learned counsel.
Civil revision.
The opportunity may be given to the students like finding an active knowledge.
Affidavit in opposition.
No,
Ask your senior.
so my
Learned counsel, it won't be affidavit in opposition.
and moreover, this order has been passed without giving opportunity. That day was fixed for acceptance of the commissioner report. Commissioner submitted the report. I have enclosed the report that the resort has dilapidated condition. It cannot be repaired. New construction required. And I cannot permit the unauthorized occupant to make new construction over my landed property. Now, without giving any
Learned
opportunity,
counsel,
this order has been
One of
passed.
you seek instruction and apprise the court.
Not should I wait that this will fix tomorrow or?
Tomorrow is holiday.
So not so that instructions can be taken from the client.
And repair work is going on. Even police and even
Tomorrow-
in my absence,
Tomorrow it can be fixed.
tomorrow, my lord, I think holiday.
No,
No. Then no problem.
tomorrow it can be fixed.
I think they're not taking instructions from a senior.
You seek instruction. Have you understood the matter?
Even, my lord, one thing I would.
Show a copy to your senior and receive the instruction and apprise the court.
And what happened on 30th December when I was not at station, that day the others had filed an application under section 151 seeking direction against the station house officer, police station Swarajdi to execute the order. And that order has, in my absence, order has been passed. Now in presence of police, repair work is going on there.
Where is the petition? Petition is in page number.
Yes, I'm. Page number 90. 90.
90. Had you filed any objection?
I didn't get any opportunity.
It was served upon you.
Copy was served upon same day, 3 application has been filed. The application under order.
We are concerned with this application
Yes.
only, Learned Counsel. Why are we making the matter complicated?
Before.
It was filed.
Yes, before filing any written objection, this application was disposed of.
No opportunity was given to you.
No. Because when I filed, I was waiting for the commissioner report. That application was allowed, commissioner was appointed, commissioner filed the report. And the day was fixed.
Can we produce the order sheet? Copy of the order sheet do you have?
No.
Yes, Learned Counsel.
Lordship, I believe that it takes day after tomorrow, Lordship. Inspection will be taken.
My lord, the lower court record is here only. If it is
Here order, it's your 55.
Yes, yes, yes.
There are dates.
I appear for the respondent, Lordship.
Why the matter has been placed under the heading to be mentioned? Are you aware of?
Yes, Lordship, there was some change in date that was requested by council, therefore.
That is required to be ascertained, the dates.
Yes, Lordship.
Yes, no, it was, have you provided the list of dates?
This about the handwritten, your lordship. I will,
You state the dates.
yes.
As regards to item number 1, CO 56 of 2024.
Was filed on 15/4/2021.
The suit was filed on suit for
The partitions.
partition suit. The partition suit has been filed on
15/4/2021.
15/4/2021. Yes.
The additive injection was passed on
In-
22/4/2021.
One minute, in bullet form, you take this, there will be. Ad interim order of injunction. Ad interim temporary injunction, temporary injunction was passed on
22/4/2021.
22/4/2021. Yes,
Then 4/1/2022, defendants appeared and undertake to file wakalatnama.
defendant appeared on
4/1/2022.
4/1/2022 and filed wakalatnama.
Undertake to file wakalatnama.
Oh, and undertook to file wakalatnama.
Then on 9/9/2020, I filed an application under order 40 CPC.
Hmm. 9/9.
9/9/2020.
I have to stay or you can
Then your lordship,
order 40 receiver.
40 CPC.
Hmm.
Then 9/11/2020, performer defendant appeared.
Pro forma defendant
Performer defendant appeared
on
on 9/11/2022.
9/11/2020. Yes.
But they did not file any written statement.
Who is the pro forma defendant? Who is the pro forma defendant?
Performer defendant who is in occupation of the part of the property.
Acha, pro forma defendant is the person occupying the remaining part of the property.
Then no written statement filed, any party, no objection. 11/10/2023, as party order.
One minute. Within the court premises.
It's outside.
Oh. Next point.
11/10/2023, against both the defendants, ex parte order was passed.
Ex parte order of injunction, temporary injunction.
To proceed the case ex parte.
Acha,
11/10/2023,
the, on-
proceed ex parte against both the defendants. 11/10/2023.
11/10/2023. Yes.
Then 21/11.
Okay, order was passed.
To proceed ex
No,
parte.
to proceed the suit ex parte.
Then 21/11/2023, another it appeared and filed wakalatnama. But no written statement, written objection or vacating ex parte was filed.
Yes. Next.
15/3/2024, additive order was made absolute. Temporary injection application was disposed of ex parte. 15/3/2024.
Is that switched on? Microphone switched on? Direct counsel. Yes. Thereafter,
7/6/2024, order 40 CPC was allowed ex parte.
yes.
Then 25/7/2024. They appeared, defendant appeared and filed a petition for vacating ex parte order and shifting the suit. Recall of order dated 7/10/2024 and also filed WS. Thereafter, 16/8/2024, order 9 rule 7 CPC was allowed. Now the matter is fixed on 17 of this month for hearing the remaining applications. So it is a dilatory tactics from inception that other part of that will remain.
Learned counsel, have you heard about
Yes,
this?
Lordship.
So, the aforesaid facts, considering the aforesaid facts and circumstances, the trial court is requested to pass the preliminary decree in the partition suit, including the pending applications filed on behalf of either of the parties, preferably before the annual vacation, that is Puja vacation of 2025, without granting any unnecessary adjournment sought for by any of the parties. So,
I will give.
you can compare that one. And in respect of next item,
Your lordship, the partition suit, it is also
one minute. CO 57 of 2024.
This is also partition suit filed on 15/4/2021.
This has been filed on
15/4/2021, partition suit. Ad interim was refused on 22/4/2021.
ad interim refused on
22/4/2021.
22/4/2021.
28/3/2022, defendant appeared and undertake to file wakalatnama.
On 28/3/2021.
3/2022.
Defendant appeared.
28/3/2022, defendant appeared
22. Yes,
and undertake to file wakalatnama.
yes.
Then another counsel appeared on 6/6/23. But no petition filed, no written statement was filed. So on 9/10/2023,
Another counsel appeared means through wakalatnama.
they filed wakalatnama, but nothing was filed, no WS, no WO.
Another counsel appeared through wakalatnama. Yes.
Then 9/10/2023, case was fixed to proceed ex parte.
Hmm.
19. Then 24/11/2023, temporary injunction application was allowed ex parte.
Yes.
15/7/2024, the receiver application under order 40 CPC was allowed ex parte. 26/7/2024, 15/7/2024, order 40 CPC was allowed ex parte.
Yes, next.
Then 26/7/2024, they appeared and filed a WS, show cause and vacating ex parte order petition.
Yes.
This is the dates.
The,
Now matter is fixed on 17 of this month as earlier.
17th, it is fixed. So in respect of both those, you provide the list of dates,
Yes.
written list of dates.
डाउट होगा तो नंबर लिख दिया हूँ ऊपर.
In this matter also the same.
Same.
Will be requested to pass preliminary decree in the partition suit. This is also partition suit,
Partition.
including the pending applications filed on behalf of either of the parties, preferably before the annual vacation,
Annual vacation.
Puja vacation of 2025.
Lodge.
I'm grateful, my lord.
Lordship, I am for the petition. This is that matter, Your Lordship, where the final decree was passed and then the
WPA.
Your Lordship, because after the final decree was passed,
Hmm.
entire matter was placed before the Tehsildar for correction of records.
Hmm.
My lord, it is under process, my lord.
So let it,
Let us
and-
submit.
entire matter was placed before the Tehsildar for correction of records. That is pending.
Oh, hearing the Tehsildar was the advocate commissioner, no, not advocate.
Yes, yes, yes,
He was
yes.
the
Partition commission.
Partition
partition
commissioner.
commissioner.
Yes.
Preliminary decree has been passed on.
Daytime.
(27/7/2012).
Yes, 27th July 2012, preliminary decree was passed. And
Thereafter,
thereafter, Your Lordship,
was,
applications were filed for final decree.
no. Whether it was amicably settled,
No, no, no.
not
no.
amicably settled.
Then order 26 rule 13 application was filed
Hmm.
for appointment of commissioner. Commissioner was appointed.
Hmm.
Commissioner has carried out the commissioning work.
The Tehsildar was appointed on.
Your Lordship, he was appointed on.
List of dates, Lord Council.
Your Lordship, commissioner, the date of appointment of commissioner is not there.
The list of dates should have been prepared elaborately.
January
Lord Council.
2022.
Kind enough to furnish a elaborate list
Yes,
of dates.
Yes, I'll do it.
When?
16th? 15th?
Day after tomorrow.
Yes.
Day after tomorrow.
Day after tomorrow.
The list of dates. Then, so it is, he was appointed on
18th January 2022.
18th January 2022.
Yes.
Yes.
Now
Since then, he is carrying on the work of partition. Commission work is
Yes,
carried on since
yes,
then.
yes. He
There is-
carried out and he submitted the report on 23rd March 2022. March 2022.
23rd March, report of the partition commissioner. Hmm.
Thereafter, final decree was passed. On 27th
Was the-
July,
Was the partition commissioner, did he adduce evidence, was required to adduce evidence, or was it accepted?
accepted,
Accepted.
accepted. There was no
Without consent.
objection.
There was no objection. Yes,
And then final decree was passed on 27th July 2022.
final decree,
Yes,
where from,
page number 38. Actually, by mistake, the 2012 is it is written, whereas it should be 2022 because kindly see the signature of the judge
No.
concerned.
in the synopsis, it is written 27/7/2012, that is the preliminary decree.
Preliminary decree.
Huh.
I am speaking about the final
Final decree, page 38.
38.
38. Yes.
Actually, by mistake, the same date is mentioned. Signature may be seen, date below the signature, 14th March 2023.
14th March. 2020. So final decree has been passed on
14th March 2023.
14th March 2023.
Yes.
Respondents are
Tehsildar,
apart from Tehsildar.
nobody else. Because I am seeking that record has to be corrected in terms of the final decree. That's it.
1 minute. And in respect of the other defendants who were in the partition suit, they have not been made a party.
No, Your Lordship, that is not required because they have never objected. No appeal is there. Nothing is there. We have filed the application before the Tehsildar for correction of
For
records in
correction
terms of
of,
records, revenue records in terms of the decree, final decree. The application is as page number 40.
Place the portion, relevant portion, place the relevant portion on person,
The representation, Your Lordship.
place the relevant portion which you have sought for, clarification or rectification.
Yes, Your Lordship. It is therefore requested to your good self, last paragraph of page number 40. It is therefore requested to your good self to kindly correct the records pertaining to land bearing survey number this, measuring this, hectares situated at Sipighat village, Port Blair Tehsil, South Andaman district, comma, land bearing survey number this, measuring this, situated at Sipighat village, Port Blair Tehsil, South Andaman district, and land bearing survey number this, in terms of the final decree and judgment passed by the Honorable Civil Court.
In the final decree,
Your Lordship.
what has been passed?
Your Lordship, final decree, the shares of the parties have been declared.
No,
And
you have sought for correction.
yes,
What is the error in the final decree?
there is no error in the final decree. Final decree is final. On the basis of the final decree, the Tehsildar has to correct the revenue records. How it will be corrected, I will show you, Lordship. Kindly come to page number.
Originally, it was 54.
Originally, now it is divided.
Originally 54.
3 survey numbers are there.
One is 54. The other one is 53/2. And the last one is
299.
299.
Now, Your Lordship may kindly come to page number 31. Your Lordship will get the answer.
That will be either 54/1 or something.
That's what I wanted to show, that it is to be his own report, his own map. Now records have to be corrected accordingly.
What was the recommendation? What was the recommendation?
This is the recommendation. This is the recommendation. Page number 31 is the recommendation. Now kindly see the survey number is mentioned.
Which one you are getting?
Sharda Pandey, number 1.
Sharda Pandey.
Number 1. 53/2/3 measurement. 54/1 measurement.
52/2/3.
Yes.
54/1.
Yes. Now records have to be corrected.
These are the two, 54/1 and 53/2/3.
Yes,
Anything more?
nothing, Your Lordship. This is only I want. Record is to be
My
corrected.
Learned Counsel.
My lord, first of all, my lord, the advocate commissioner was there. It's not the tehsildar, was
No,
not
no,
the partition
tehsildar.
commissioner. My lord, may kindly come to page 23. 23, my lord. It is on the
Okay.
basis of the commissioner. Commissioner was one, it's advocate. It's one of the advocate.
Page
He was
23.
appointed as commissioner.
Page
My lord,
23.
page 23.
Hmm.
This is the commissioner's report.
Hmm.
And who is the commissioner? It's not the tehsildar. The report has been submitted by the partition commissioner, who is an advocate. It's not the tehsildar.
Siddhartha Singho.
Yes, my lord. He is not the tehsildar. Tehsildar has
Along with the tehsildar, I will show from the record.
Thereafter, my
Tehsildar
lord,
only assisted him.
I have
Yes.
taken on instruction, I am submitting, my lord. My lord may kindly come to, because after going through the judgment, they are a little bit confused, because in the judgment, it's written that Ashok Kumar Dubey is no more. He's dead.
No, he is alive.
And my lord may kindly come to page 20. It's a judgment, whereas it is written Ashok Kumar De, who died unmarried without any issue.
On
Page 20, my lord. It's a judgment passed by the trial court, wherein it has been mentioned that Ashok Kumar Dubey, who died unmarried without any issue. It's 1, 2, 3,
Wherein?
4, 5, 6, 7. 12th or 13th line, my lord, from top.
yes, Ashok Kumar Dubey, who died unmarried.
Married without any issue.
No, that is the further case of the plaintiff. Further case of the
But
plaintiff
this is
that
not the case.
plaintiff-
Ashok Kumar Dubey is alive. He's alive.
Your Lordship hardly matters because in the judgment, yes, let her complete. Then I will.
Let me be acquainted. I am not
Yes.
acquainted with the facts.
Your Lordship.
That may be or may not be.
Let
The-
her complete.
The
I will
contention
clarify
which
that.
is being raised.
Yes.
Further
So,
case of
there was a
plaintiff-
confusion regarding this. Since in the judgment it is written that Ashok Kumar Dubey, who died unmarried.
Hmm.
It is written in the judgment. Whereas in the commissioner's report, my lord, the advocate commissioner has given the
That is not the inference.
my lord.
It is mentioned during pendency of the suit, the defendant number 1 died and his name was deleted from the cause title of the plaintiff. Further case of the plaintiff is that plaintiff had another brother, namely Ashok Kumar Dubey,
Yes,
who died unmarried.
this is the
It is the
wrong
case. It was the
It is-
case of the
But
plaintiff.
it is a wrong submission because he is alive.
We are not concerned with
My-
his submission of that. We are
So-
concerned that.
My lord, it is under process, my lord.
1 minute, Lord Lord. As I have got that according to the final decree, page 21 of which page you were? Page 31. According to the final decree, the petitioner has obtained 53/2/3, measuring an area of 3,500 square meter, and 54/1, measuring an area of 2,081 square meters.
My lord.
And when the prayer has been made before the tehsildar,
October 23.
October
23.
18th October 2023.
It's page 40, my lord. Page 40.
Hmm, 18th October 2023.
2023.
Hmm. 1 year, 3 months have passed by. Not
My-
counted. Yes, what is the?
My lord, there are other co-tenants also. It takes some time, my lord. It is under process, and today I have, on instruction, I am submitting, my lord. They are going to send the report by today to the tehsildar, before the tehsildar, the Patwari concern. The area Patwari will send the report to the tehsildar by today.
Okay, thereafter, what is remaining?
Thereafter, the tehsildar will do the needful, my lord.
So within how many weeks?
It takes some time, 4 weeks, my lord.
4 weeks.
Let it be 6 weeks, my lord, because other co-tenants are, let it be 6 weeks, my lord.
6 weeks.
Your lordship, I have waited for 1.5 years, 6 weeks, I can wait.
6 weeks from this date.
Mine.
Acha, the learned counsel is to convey. Representing the Tahsildar is to convey. Need not be.
I appear for respondent.
I am for the petitioner.
I am appearing for respondent.
In August, just a small prayer, I given a representation for mutation of the land as per the will to the Tahsildar Ferrarganj. That was not disposed, Your Honor. A direction may be given to dispose of my representation in accordance with law, either they may reject or.
When have you made it?
The representation was in the year 2017 and in the year 2018 and also in 2023.
Where are the representations in page number?
Number 11, 12, 13, 14.
12 is dated
12 is dated
13/9
13/9,
2017.
2017.
Next one.
Next
dated-
22/3,
One
2018.
minute, 1 minute. Hmm. 22/3/2018.
Yes. Third one is 19/7/23.
Third one is 19/7/23.
23. 23. Yes, madam. Is the last representation.
19/7/23. 19/7/2023. So, yes, anything?
Nothing. Direction may be in either they may dispose of, they may reject
Right, counsel.
in accordance with.
Representing the.
I am representing the respondent, my lord.
Do you have any instruction?
Yeah, my lord. We have received the copy today.
Today, why?
My lord, simple prayer, my lord. Just let them dispose of my representation.
Let him have the instruction.
Either dispose karo, reject karo.
Dispose of, can it be disposed of?
Yes.
With the
if your-
direction-
If
the
your
direction-
lordship,
With the direction to take.
To dispose of my representation
Dispose of the applications.
in
within-
accordance with law.
my lord,
In accordance with law within 4 weeks.
Yes, my lord.
4 weeks or 6 weeks.
6 weeks. Within 6 weeks, and to apprise the opposite party, the petitioner accordingly.
Obliged.
Opportunity of hearing, my lord.
The instant, the present writ application has been preferred by the petitioner. By the writ petitioner. As his 3 prayers made to the made So 9, WPL 315. WPL 315. We are paying for the respondents, Malord has already heard.
Lordship, my senior is appearing for the petitioner.
Begin the set. Be on the side. Which one? This is that shop, Malord. Fruit vendors. Malord, that fruit vendor shop. No, fruit vendors, yes.
Hearing was concluded, Your Lordship. My senior had submitted on the last action that she would be placing one judgment before this honorable court. That we doing so this. As a.
Have you produced?
Your Lordship.
Let a copy be given.
I'll be providing the citation.
Should let that copy be given so that we can reply to that if required. Refer the citation. Refer the citation. 2020. Yeah, Supreme Court 1036. Not one. 136, my lord. Hey, you are providing this one to the court. How can you provide? See this one?
Apologies, Your Lordship. I'll be providing another copy of it.
Hmm. Password.
Your Lordship, I pray for a short passover. I'll be providing the other one.
Have you taken note of the citation? Yes, my lord. 2020 AR Supreme Court 136. You refer.
I'll be providing the copy of the judgment. As
No, it's the reference. Provide the citation only. It is the reported judgment, you provide the citation. First one. So, learned counsel, it is being fixed. You provide the citation, it is being fixed for tomorrow. Yes. If you want to give any reply, you can give a reply to that. You provide the copy of the citation. Today itself. The learned counsel representing the petitioner refers to a So tomorrow,
There will be a resolution because.
Acha. Oh, acha.
14.
Oh, 14. Item number 14 is fixed on 14th, Lord Council.
14th, my lord. Because my lord has directed me to serve, file reply today and fix the matter tomorrow for hearing. Because as per the earliest order, check kariye, I see. 13 reply has to be filed and matter is cancelled.
So you can
I filed the reply, my lord, because I've not seen the other side. So it's now with copy.
let the copy be provided.
Yes,
Tomorrow you file the reply.
I already filed the registry. my lord.
Acha.
I'll file it. Item 15, WK 689 or 2024.
Lord, I am for the petitioner. There is a direction upon me to serve the private respondent. I dispatched by speed post. I am not yet received the track report.
Not yet received the track report.
But my lord, by WhatsApp I served. That is also service, my lord. During the COVID period, my lord, WhatsApp service was accepted.
Exceptional circumstance, Lord Council. So next circuit.
I leave to.
For respondent of 4 and 5.
The same connected matter is fixed tomorrow, but it's definitely so, sir.
It's tomorrow. But they don't have to file opposition, no, in any circumstances. You don't want to file.
That will be fixed tomorrow without.
Your Lordship, tomorrow I might be having some difficulty, Your Lordship, because of the puja, Your Lordship. Tomorrow the festival is there.
Day after tomorrow,
Day after tomorrow.
day after tomorrow. So at least somebody be there
Yes, sir.
to
Yes, yes.
represent you.
Your Lordship,
So the matters can be taken up day after tomorrow.
Your Lordship.
um, on consent of all the sides, let the matter be fixed on um,
Right. 2, 3. 4 and 5.
two, three, four, five, 8 and 9. What about one
Pondicherry University is also party to the proceedings.
learned council? What about they are representing 2, 3,
4 and 5.
2, 3, 8 and 9.
I appear for
Learned
4 and
council,
5.
Mr. Balan is representing
4 and
4 and 5. So 2, 3, 4, 5, 8 and 9. What about 6, 7, 1, 6, 7, 7?
Lord, 9,
Service
10,
is complete.
2 and 3, 9, 10. I am
Service is
appearing.
complete.
Day after
2, 3,
tomorrow.
9, 10.
Your Lordship.
Day after tomorrow.
2, 3, 9, 10. 2, 3, 9, 10.
Give the correct numbers, learned council.
2, 3, 9, 10.
My lord.
Lord, this is item number 9, the citations. See, yeah, order should be correct. 3, 6.
Yes.
Next is this fixed tomorrow for
Citation,
giving.
that food vendors.
Yes, yes.
It's on the ground of human dignity, that's it. Nothing more.
Order sheet, 1360.
Have you provided the clear one?
Yes, yes.
This one is okay.
PDF major one.
Acha,
Item 22, automatic shower, item 4.
I'm for the petitioner.
petitioner.
Service has been affected, Your Lordship.
Hmm.
There's a delay. So that delay has to be condoned before the matter could be taken up, but nobody is appearing from the insurance company.
Oh, 2 years, 3 months and 6 days
Your
delay.
Lordship, MSCT matter, the poor people, they don't know what is the implication, how
At
the
least-
amount is to be
At least,
calculated.
oh, the registered owner of the bus.
Yes,
Herein, there is no registration of the bus with the
insurance company.
insurance company.
Yes.
It was not insured.
I have already informed Mr. Lokesh Cherian also, who appeared before the learned court below. I've already informed him.
On behalf of the owner.
Yes. But today he is not appearing. Affidavit of service has been submitted here.
Yes.
Track
aff-
report is there.
Affidavit of service. Learned. Oh, this is no. The learned counsel representing the appellant submits that she will inform the learned counsel who was representing the respondent opposite
Yes.
party before the trial court during the course of this day and seeks an accommodation for this week. It was taken up on 9th.
It's there. The notice is also there to the council.
through WhatsApp.
Yes.
Is the learned counsel not a regular practitioner?
Yes, Your Lordship.
Regular practitioner.
Yes.
So, let him be served
Yes, let it be,
through hand.
let it be on 16th. I will do it again.
16th means
Thursday.
Thursday. Let the learned counsel, why not day after tomorrow?
Yes, let it be on 15th.
And-
Because tomorrow I will be having some difficulty. No,
Day after tomorrow.
it's true, Your Lordship, but
Okay.
I have to search him in the court. So tomorrow,
So on the prayer of the learned counsel, first which is affidavit of service. Affidavit of service has been filed. Let the affidavit of service be kept with the record and full stop. The learned counsel seeks an accommodation for 2 days. Let the matter appear on 16th.
16th.
Union of India. No, you are watch it and others. In one matter, 1 minute. In one matter, the day before yesterday, no, on Friday, the learned counsel has yes, learned counsel, Mr. Hussain. Yes,
Below, I am appearing in the item number 23 below.
item number 23.
Yes,
Yes.
below.
CO
Yes,
2022.
yes. That's why I did not join below.
What?
23 is CO4 below. CO4.
22. For the,
Yes.
for
I'm for the respondent below.
all the
20 No, only one private respondent. I'm the plaintiff respondent below.
private respondent.
Yes, plaintiff. Lord, here below, my leader is Mr. Below.
1 minute. Private respondent is
Andaman plantation below. I'm below Andaman plantation.
Andaman Plantation.
Yes.
Andaman Plantations and Development Corporation.
Yes. I'm representing. The Andaman plantation, my lord, is the plaintiff in the suit.
Private limited company.
Yes, it's a private limited company.
Individual. I was searching for an individual. So,
Yes.
other is brief note of submission.
No, I was the sole defendant, my lord. Lord, before my learned friend proceeds with the matter, my lord, may I just indicate, my lord, in this matter, my lord, my leader is, my lord, Mr. Ratnamko Banerjee, my lord. He wanted to do the matter, my lord, but my lord, he is not available. If still my learned friend insists, my lord, to do the matter, my lord, I will not oppose, I will not stop the hearing, my lord. But my lord, only thing, my lord, your lordship will consider, my lord, this is a uh, uh, high volume matter, my lord. And I also we wanted to do, my lord, physically before your lordship, my lord.
So
No,
what
no,
is
if, then let her, if my learned senior is, Mr. Banerjee is appearing, let him make a, I mean, Mr. Asif can make a request, at his request, let it be adjourned to the next circuit.
What is the prayer, learned counsel? What is your prayer?
My lord, if you could be adjourned till next subsketch, my lord, it would be better for both of us, my lord.
At his request, man.
My lord, subject to your lordship consideration and my other side. My lord, if he wants to do the matter, then obviously I will participate. My
If
lord.
Mr. Banerjee is requested, my lord, it'll be, my lord, we can't come in the way, my lord. Let it be at his request.
Mr. Asif Hussain, representing through word. Okay. It's accommodation on the ground of senior. Full stop. And further praise for fixing the matter, placing the matter before the next circuit bench. Accordingly, let the matter be placed before the next circuit bench.
I'm so grateful. My lord. I'm so grateful.
In this matter, somebody was representing you on Friday, seeking that the matter be placed at the number 1 slot.
Yes, my lord.
Oh, my lord.
Yes. He is present. He is present.
I planned to come today, my lord, but my lord, due to
Okay,
some difficulty, my lord, I could not come, my lord. I wanted to come today.
it will be heard by the next circuit bench.
Grateful, grateful.
My lord, I am appearing for the appeal, my lord. I need some time because I have to take some instruction from my client. He's a resident.
So you do not intend to hear out the appeal.
It will take some time. I need some instruction from my client also.
I am ready to hear.
In that case, my lord, let it be on day after tomorrow.
You start today.
My lord, some instruction is required from my client.
Why not tomorrow?
Tomorrow I have some difficulties. Day after tomorrow, no.
Day after tomorrow is? Day after tomorrow?
15.
Wednesday. How much time will you take?
It will take some time.
How much?
1 hour.
1 hour. You are for the respondents. Please come on this end. How much time will you take?
Lordship, I will take 1 hour.
1 hour.
1 hour.
Both of you are ready for hearing so that the matter can be taken up day after tomorrow?
Day after tomorrow.
Paper books ready?
Paper books.
Paper books ready. What is the matter involved?
My lord, I have challenged the judgment and decree passed by the London District Judge. Here, there was a suit and counterclaim. I filed a suit for cancellation of an agreement. My case before the London trial court is that by committing fraud, my signature was taken on some documents by false representation that is for the purpose of taking some permit from the Naval Department, because I am working I am navigating a tourist vessel. So signature was obtained. When I got information.
Navigating a tourist vehicle means you are the owner.
No. Working. Under one, working.
Achha.
Because
employee in a tourist company. Navigating
tourist vessel. Now my owner, he brought some documents and.
Oh, the dispute is between employer and employee.
No.
Achha.
Brought some document, took my signature. Subsequently, when police called me and produced those documents, I found this is a sale agreement. in respect of my landed property in between me and the respondent here. Because the respondent and my owner is a very good friend. They are business terms. I filed a suit for,
Registered sale deed,
no. Sale agreement only.
sale
Not a-
agreement,
not a
sale
sale
agreement.
Sale agreement.
Oh.
I filed a suit for cancellation of the sale agreement.
Hmm.
Now the respondent had filed the counterclaim.
Achha.
Counterclaim for specific performance of contract.
Hmm.
My suit was also dismissed for limitation. It is barred by limitation. I have not challenged the sale agreement within 3 years. And their counterclaim was also dismissed because there is a specific time granted in the sale agreement, sale agreement, that within 6 months it will be sale deed will be registered. But after 5 years, when I filed the suit, they filed the counterclaim. Their counterclaim also dismissed.
Achha.
Now, the dismissal of counterclaim tantamount to cancellation of the agreement.
Hmm.
I have not challenged the same. Subsequently, I have challenged. Now, the respondent challenged the judgmental decree passed by the learned trial court before the learned district judge.
Hmm.
District judge held that when the suit filed by me for cancellation, limitation arose from that thing. So this is not the law. And the appeal was allowed. And I have been directed to execute sale deed in favor of the private respondent. I have challenged this one before this one.
What is the substantial question of law frame?
Yes. I have enclosed. Page 258. Paper book.
One volume, in one volume,
One volume,
258.
250. There are 3 substantial questions of law framed by the Honorable Division Bench.
One more. Whether the learned first appellate court erred in allowing the counterclaim without deciding whether the counterclaim is barred by Article 54 of the Limitation Act. Whether the learned first appellate court misconstrued the Article 54 of the Limitation Act. Whether the learned first appellate court misappreciated the evidences led at the trial. Achha. Hmm. One thing more. The paper book contains plaint,
Yes.
written statement containing the counterclaim,
Yes.
written statement of yours against the counterclaim.
There are the evidence.
Evidence of PW1. Only one witness
No,
adduced
3.
evidence.
No, PW2, PW3.
Achha, 1 minute.
3.
Documents exhibited by the plaintiff appellant being exhibit 1 to exhibit 5. The documents exhibit 1 to exhibit 5 are there. Evidence of PW2, evidence of PW3. How many documents did you furnish? Exhibited?
Several documents.
No, 1 to 5. 1, 2, 3, 4, and 5. That is
Yes.
page 50 to 59.
Yes.
Apart from that, apart from those, no other documents.
No other document.
1, 2, 3, 4,
Now the
5.
defendant also.
Because I'll hear both of you. You will get ample opportunity to submit. But it won't be possible to deliver the judgment herein. I'll have to go to the mainland and thereafter prepare the judgment and deliver the judgment virtually. That's why I'm going through the paper book, whether it contains each and everything or not. Achha, the record of the trial court and the first appellate court are here.
LCR.
Both of you go through the record today itself.
Yes.
That the entire record of the trial court, including the evidence, oral evidence of all the witnesses and the documentary evidences are there, which have been exhibited. from the, on behalf of the plaintiff 1 to 5. Thereafter, DW1, PK Deepak Kumar, documents exhibited A, B, C, D, E, and F. 6 documents. Go through
Lordship.
that, the entire evidence is there and all the documents are there. Both of you learned counsels. Is there a tin box? No tin box.
Noting. No.
And you also go through the entire paper book also. Therefore, the evidence of DW2, document exhibited by DW2, exhibit G. Apart from A to F, exhibit G. Evidence of DW3, exhibit H, exhibited by DW3. Therefore, thereafter, evidence of DW4, exhibit I, J, K, K1, K2, K3, exhibited by DW4. Written argument, file on behalf of the defendant, respondent, judgment, trial court judgment, memorandum of first appeal, written submission, written notes of argument, impugned judgment of the first appellate court. Yes. Then it comes to today, both of you go through the records that the entirety is here, including the oral evidence and documentary evidence. Thereafter, so that we can start day after tomorrow. Day after tomorrow. So the matter will be. It will be taken up, but after conclusion of the other matters.
Yes. If it is taken up in the afternoon after lunch, then.
Yes, it will obviously it will be taken up after, not prior to 2 p.m., but after the conclusion of the other matters. Thereafter,
Yes.
you will be provided the entire remaining period.
Lordship.
How long you take? There is no hindrance to that.
Only the limited question based on the question of law, limitation.
Yes, not beyond the substantial questions of law. Any other substantial questions of law to be framed?
No,
No.
not yet.
So everybody will
It
have.
confined only with regard to limitation.
Yes, everybody, both the sides will have to be confined within the 3 substantial questions of law which have been framed.
Lordship.
Be kind enough to go through
Yes.
the record.
Get full.
But it's the judgment.
Where is? Have you, this is not a,
It is reported.
reported citation?
Reported in the local journal, ILR.
I'll go through. So it will be at
Tomorrow.
least tomorrow or day after tomorrow? Which
Day after tomorrow.
Day after tomorrow. Which one, item number?
6.
6.
6.
Item number 6. Item number 25. I think the advertising report is submitted in. What is it doing there? What is it doing? Condition is not yet improved. 25. Next circuit bench. Next circuit bench. On the prayer of the learned advocate representing the petitioner. You are representing which respondent?
All the respondents.
2 set of lawyers are there. One set for the respondent number 1, the other set for the respondent number 2. On the prayer of the learned advocate representing the petitioner.
Yes. For the investigation, and last edition, directed us to draw a copy to conceal ourselves by using our. So it was solved. And I is trying already then I got a filed a application about it.
1 minute.
It's extension of time to filing it.
Affidavit in opposition is there. But, the learned counsel.
Shoot at his nest.
December 11, your last term, don't have direct.
December 11.
But it was not reflected.
Shoot written estate.
Learned petitioner prays for extension of time. Learned advocate petitioner prays for extension of time to file affidavit in reply. Last extension was granted on August 17. Last extension was granted on August 17, 2023. But no affidavit in reply has yet been filed. However, for the ends of justice, time is extended for 2 weeks. After all, there is no, I am unable to find any direction. No direction at all. By order dated December 11. The learned counsel.
It is a very serious matter. Where the petitioner seeks that he should be given a license for petrol pump. And there is no direction.
The Union of India has not been. No, please. No, the Union of India is a party.
They have not been served.
Not been served.
Service has been affected on me.
So on direction.
On the condition there is a direction by the court. I don't find any direction to this on the court.
No, 1 minute.
I am also interested that the matter should be sent to the ministry to take their opinion. But where from?
But the Union of India is a party, respondent number 1.
Why not? If they have not served to the Union of India, if they have served, they will appoint the MOLJ. MOLJ will direct us to appear in the matter. In the pretext that this honorable court has directed that the service to be affected on me, in that pretext the service is affected.
Oh, upon you personally.
G.
What was directed me to service.
This is what.
That's what for that reason I had served a copy.
Has the Union of India been served through represented through the secretary being?
I saw a fresh copy to Union of India.
Hmm. From
Anybody is representing?
Additional reason appearing in the person.
So it's
Not there.
it's not there. One is representing, the petitioner is not representing, no?
No.
Not today.
Second 28, WP 314 of 122. My lords.
28. 28. Content document.
We are appearing for the respondent. Today only I have been engaged by the client. I need some time. We only received the envelope. Let me go through the 2%.
Before the next.
Sir.
Yes, at the request of Mr.
Maybe I recorded.
See, oh, you have not filed Wakalat now also.
Undertaking of the work.
Any, owner number, any? Mr. Vijay Kumar undertakes to represent the
Oblige.
30, that would be 849 or 173.
For private respondent, my lord. And it is fixed for filing the reply by the petitioner, my lord.
But I'm praying 1 week's time, my client is out of space and is coming on Sunday only.
Then the advocate representing the petitioner seeks further 1 week for filing affidavit in reply. Consider let the matter appear before the next circuit bench. নামগুলো নিয়ে নেবেন।
Your lordship, let it be day after tomorrow, your lordship. Accommodation only from day after tomorrow.
Joint counsels. Prayer.
I have nothing to say, my lord. Keep it up. At the request of the private respondent.
So you are representing the private
Private
respondent.
respondent.
Respondents. So, no.
It's one private respondent only.
One private role.
Rest are state respondent.
Andaman Nicobar Administration.
I am representing.
Secretary. Port
I am
Blair Municipal
Yes,
Council.
yes, my lord.
You are representing Praveen, Sri
Yes.
Praveen, without any surname. Mr. Sri Praveen.
In South India, my lord, there is no surname.
There is no
Don't
surname.
use.
Only the name.
Or father's name is used.
Father's name initial. First letter will come.
First alphabet of father's name.
Yes.
No, sometimes full father's name is also used. Father's first name is
Only
also
passport
used.
we use.
Huh?
Only in passport,
Acha.
otherwise only initial.
Father's name first, thereafter your name.
Yes.
Mrs. Anjali Nath, senior advocate, representing the sole private trust.
Item 32, WPA 887 of
I pay for the respondent, my lord.
Lordship, in this particular matter, Mohammed Tabreza is looking job with petitioner. We submit a file reply here. They have already been filed.
For the petitioner,
Your
you have not filed affidavit in reply.
No, you're not.
Since when?
What?
It is a very lengthy affidavit in reply.
You're not actually. Meanwhile, he have went to the major for his.
No, it's since January 2024. Although direction, this is the order of 16th January. Order of 16th January 2024. Let here, the affidavit in reply, if any, be filed by 31st January 2024. So, nee. From Namtani level, Mr. Learned Advocate, representing the petitioners seeks further accommodation for filing affidavit in reply.
Item 33, WPA 912 of 2023.
I pay for the respondent. All 1, 2, 3, and 4.
For the instruction of the judge, you to file or slide. Because the.
I had seen Mr. Jaipal today. He is there.
Respond number had filed their application on 21st, you are 24.
When you have filed the affidavit in opposition.
In the month of July itself, we have filed. July 2024.
Respondent number 5.
I am appearing respondent 1, 2, 3, and
You are
4.
representing the
Official respondent. 1, 2, 3,
respondents of
4, and
1,
4.
2, 3, and 4.
Ah.
5 concept is there.
5.
We filed on 3rd July 2024.
Yes, it has been filed on 3rd July 2024. And the affidavit in opposition on behalf of the respondent number 5 has been filed.
Five.
Prior to that,
5 has been filed on
before that, it has been.
11. It seems 11/1/2023.
He was big, yeah, it's today copy of.
Mr. Representing the petitioner submits that the petitioner intends
Let it be passed, let it be not today. I'll inform,
Item 34, W39, 5/1/2023, matters filed arguments. I'm appearing for the Forest Department by not petitioner in
Item number 34.
for hearing. 34. Any matter also appearing.
I am those are connected.
Requires hearing.
What do you intend? Name. Name.
Let it be recorded at the request of the petitioner.
Una number
The Your
11.
advocate be answered.
Una number. Provide your names. There is counsel. Una number 11. Learned advocate.
Item 36, WK 963 of Provisional Bag of Hearing for the respondent, madam, state respondent. This matter by respondent. You also responded, no? Petitioner had sought time to. I replied, my lord, in terms of petitioner's clients are sailors, so my lord, they were not able to get the affidavit. Last several occasions.
You are representing the petitioners.
No, both are respondent. He's also.
Be at this end.
Yes.
Be kind enough. Nobody is representing the petitioner.
Not to them, my lord.
Not today. Not today.
Item 37, WK 992 of 2023 will stand on October 24.
Lordship, Advocate PC Das is appearing for the petitioner, Your Lordship. He is in Kolkata, Your Lordship, and due to personal difficulty, he is unable to appear before this honorable court, Your Lordship. I'm praying, Your Lordship, that this matter be kindly taken up in the next circuit, Your Lordship.
At their request, it should accept.
I have for the private dispute.
Counter 11.
And I am there for. I've been given a copy of opposition. Let me take the privilege to use my reply link.
Mr. Jaipal. Mr. Jaipal.
Private dispute.
Mrs. Nag is appearing for the private respondent. Sorry, ma'am. In which manner you are representing that you don't know?
Actually, advocate and recall your worship.
Hmm.
He is also one of the advocates.
Advocate on
So
record.
he might have informed him to take adjournment in that matter. That's it, I think. So
Same order.
confusion has arisen.
Same order, which one has passed the preceding matter, same order.
In the early order, it was on your behalf.
Same thing would happen here.
Because opposition we have already
Both of them
filed.
have filed it, I've used it.
Same order as the earlier one. Affidavit in the file. Same order. 38th. Item 39, same order. 38, 39, same order.
But a situation have arisen here. This situation was brought to the notice of my adverse side also, but I'm helpless. They have given me a copy of opposition without 2 pages. Several times request was made to give those 2 pages so that I can use my reply.
Yesterday only he told me, your lordship, so I have.
Those 2 pages are not so important.
It's very important. It's very
Yesterday
important.
only it was told to me, your lordship. I'll provide within a day or two.
So what is the order to be passed?
Opposition in full form, Lordship, has to be given to
So,
me.
your lordship, let the filing of reply be extended, your lordship. I will provide the copy.
And the interim order needs to be extended, my Lordship.
I will provide the copy. Because they have to file the reply, let it be extended. Time to file the reply be extended, I will provide the copy.
Was in force till
The 22nd January by Her Ladyship Honorable Justice Shampa Sarkar.
22nd
January 2024. And then, my Lordship, it was time to time extended.
Lastly extended on
Lastly extended just 5/12/2024 by order of the Justice, Her Ladyship Justice Amrita Sinha.
Extended till the end of this circuit.
till the end of the next circuit.
So next circuit is this circuit.
This circuit.
Is it so?
Yes. Yes.
Her Ladyship
After-
held the circuit during last circuit. So next circuit would be this one.
After 5/12, this is the circuit.
This is the circuit.
the ICMR, my lord, in this matter.
Lordship, in this matter, my senior appears on behalf of the petitioner. My senior appears for the private respondent.
Next circuit bench,
Yes, Your.
Let it be at their request, my lord.
you are representing the petitioner, you are representing
Private respondent.
on the request. No. Uh, Who is for the petitioner? 3 and 4. 3 and 4, administration. Private respondent. Who is for the petitioner? Mr. Vijay Kumar. None is representing. None.
Lordship, in this matter, I'm seeking extension of time to file my reply. My senior appears for the petitioner.
Hmm. Hmm. Puna. Applicable reply file.
Purely question of law is involved. No, allows it, but feels that reply is in fact required because documents upon which I place reliance have been placed by the other side in their opposition.
Mr. Bokshi. Mr. Jaipal, representing the petitioner.
Procedures as prescribed under this special regulation, commonly known as Andaman and Nicobar Island Land Revenue and Land Reform Regulation 1966, the one lot which is not. My father was allotted with a piece of land. His name was duly recorded. On a fine day, the authority, in colorable exercise of their power, effect correction. And in the interest, how could the authority can take back the property?
How your father obtained the property?
It was allotted to the government by the administration.
Achha.
My father's name was duly recorded.
To that effect, you have document.
Yes. But same document at the extreme end remark column indicate that the said land has been resumed. This term resumption would not find anywhere in the regulation. There are options, there are remedies, there are modes to take back the property. One is by way of an acquisition proceeding, lordship, which is well recognized. The third is if my father willing to surrender, it's a voluntary act in terms of local regulation to the Tahsildar. The Tahsildar accept my surrender, my father's surrender, and can effect correction. Save and accept these two. There can't be a third one. They may say, my lord.
Where's the document? Page number?
Lord, kindly turn to page 33. Page 33.
Page 33.
Lord, would see extreme left, my father's name, Lord, would find record. Fakir Chaudhary. And
Okay.
Chaudhary, Chaukidar, I'm sorry, Chaukidar. Lord, would see serial number 5, the particulars and detail of land, survey numbers 26, it's classified as paddy 2, survey number 27 as house site, survey number 70 as paddy 2. And my lord would see extreme right. Same documents even they have used. The holding has been resumed sometimes in the year 1980s.
Mr. Jaipal, can a legible copy be provided?
Even they have annexed the same documents because their documents also same thing. I'll get it typed now. So I do one thing.
Yes,
I'll get it typed.
Let us continue.
No, I'll get it typed. So my point of argument, Lordship, my father never.
What is written there? What is written there?
It's resumed. I was just. It's not to see the holding has been resumed. RESUMED. They cannot deny this. There cannot be a debate on this. They do admit that it has been resumed.
Mr. Balan, the holding has been resumed. Yes.
My point
provide a typed copy.
Yes, my point of argument is I can give back my property. My father can give back the property.
You can surrender your
surrender is well recognized. There are procedures prescribed. It's a voluntary act, and our division bench have clearly interpreted this surrender also.
Either by surrender or by
acquisition proceeding.
Acquisition proceeding.
There are some other procedure also. If I use a property other than for which it has been given, if it's a paddy land, if I use it for some commercial activity, they can extinguish my tenancy. Tenancy can be extinguished and for which there is a separate procedure, the authorities is some other authority, that's subdivision officer. Now, this action of the authority has been questioned in the repetition.
What has taken place thereafter? What has
Nothing
taken
more,
place?
the records remains, I am in possession after the death of my father.
You are in possession physically?
Yes, my father died.
Uh,
Not page find, not find it page 35.
According to you, you have naturally being the sole
36.
layer.
Yes, not right on page 36, not
One minute.
cultivation of banana trees. Everything is being done in terms of the regulation only. For the purpose for which the property is given to my father. Except in one land, it's a house site. I have raised my house. I have obtained an essential amenities, electricity and water connection. What would see right from page 36. From 37, 38, these are the erected trees, Lordship. 39. So my first point, I have just argued, Lordship, this recourse which the authority has adopted to effect correction is unknown to law. That's first. Even if you want to take anything, you could have given a notice to my father, that was not done. I am deciding till now.
Which document are you challenging?
The very remark at the extreme right, the very recording that the property has been resumed.
Resumed.
But still now, Lord, my father's name is been shown as a recorded tenant till now. Because they have annexed the same documents. If it is resumed, Lordship, the course would be, they would struck down my father's name and they would record it as to be a government revenue land. That they have not done. Simply a remark has been made.
Yes.
So this is mainly two grounds. First, my father was not given a notice and there is no surrender. I'll just show the provision where my father could have given surrender, but he did not surrender it. I'll show that. Lord, can it turns to regulation? It's page 29, clause 153 of LR, the special regulation.
Clause
153.
Section 153.
153. Subject to the provision of this regulation, a tenant, who in the present case my father, may surrender his holding or any part thereof by making an application in writing to Tahsildar, intimating his intention to do so, and by giving possession thereof, whether such holding is or is not let. Now, notwithstanding the surrender, unless the tenant applies before the 1st day of February in any year, he shall be liable to pay land revenue for holding for the agricultural year next following the date of surrender. So it's my specific case, my father never surrendered. If it was not done, the authority was wrong in their action in holding it to be resumed property. That's the first point. I'll show some more provision, Lord. All right, 162, page 33.
Next.
Page 33. See section 162 at the bottom. 162.
162.
Yes, extinguishment of tenancy. The interest of a tenant in his holding or any part thereof shall be extinguished
small a, when he dies, leaving no heir entitled to his interest under the regulation, this would not have been attracted, or when he surrendered his holding or such part, that's exactly in consonance with the provision which I have shown just now, the provision dealing with surrender. That's not the case, not or when the holding or such part has been transferred, let out, or used in confirmation of the provision of this regulation. This is also not the case because no decision has yet been taken. They cannot, before effecting correction, there has to be some decision that a show cause needs to be issued to my father that you have violated these provisions of the regulation. You are hereby show cause. You have to furnish a reply why this shall not be extinguished. That is not the case. When the land comprised in the holding has been acquired under law for timing imposed related to acquisition of land, that's also not the case. When he has been ejected under the regulation, I am still holding the possession. It's my specific case in the writ petition. So long my father was alive, he was occupying the land in question. After his death, being the successor in interest, being the heirs, we are occupying it. And when he has been deprived of possession and his right to recover possession is barred by limitation, because we are in possession, the provision will not also attract. When his holding is declared as abandoned. But this abandonment, they may argue on this line that the property has been abandoned. It's 162G.
Abandoned.
Abandoned. That's altogether a different concept in this regulation. I'll show you how the amendment has to be effected, what are the procedures that one would find it section 152 at page 28, amendment of holding. Because the very remarks do not contain any reasonings, Lord. The remarks do not contain any reasonings.
So you have referred to section 153,
160,
162.
162.
Now you are referring section
152, 152, page 28.
150.
Page 28. And left hand side it will come.
Yes, abandonment of holding.
During the period of one agricultural year, an occupancy tenant or non-occupancy tenant does not cultivate his holding or leaves the locality in which he usually resides without making any arrangement for cultivation of holding, or a grantee does not cultivate the holdings given under the grant or leave the village in which he usually resides without making proper arrangement for maintenance of the holding given under the grant, the subdivision officer may, after such inquiry as he may deem necessary, take possession of the land comprising the holding and arrange for its cultivation and upkeep by letting it for a period of one agricultural year at a time on behalf of the occupancy tenant, non-occupancy tenant or grantee. Where such occupancy tenant, non-occupancy tenant or grantees or any other person lawfully entitled to land claims it within a period of 3 years from the commencement of the agricultural year next following the date on which the subdivision officer took possession of the land, it shall be restored to him on payment of dues, if any, and on such terms and condition as the subdivision officer may think fit. Provided that no such land will be restored to the possession of the tenant or grantees or other persons unless the period for which such land has been let out by the subdivision officer under subsection 1 has expired. Where no claim is preferred under subsection 2 or if a claim is preferred and is allowed, the subdivision officer shall make an order declaring the holding abandoned and the holding shall rest absolutely in government from such date as specified that in that behalf in the order. Where a holding is decided abandoned under subsection 3, the liability of such occupancy tenant, non-occupancy tenant or grantees for areas of revenue from him in respect shall stand discharged. So even the amendment, they can't take this plea also, because as till now, if it is a case of amendment, they could have struck down the name of my father, they should have restored the land to the name of government. That's not the case. And the authority is subdivision officer. Inquiry needs to be made, I need to be heard. Except these provisions, Lord, in this regulation. There is no other provision to resume this term. The term resumption will not find anywhere in the regulation. If they say that resumption construed to be taking back the property, but that has to be done in consonance with these provisions. So my argument would be, Your Lordship, insofar as those remark part is concerned, that needs to be struck down, not the entire documents. That remark column needs to be struck down, Your Lordship. I'm still holding the land, I'm possessing the land. I'm doing this purpose for which it has been granted, cultivation land. So far as house site land is concerned, Lord, I'm designing there are, I'll show the bills also, brother. And they have taken it. Is it not in this way? In a haste manner, this way, Lordship, state under Article 12, Lordship, are vested with certain responsibility. They cannot snag the property of a citizen like this. Article 3A comes to my aid. Kindly turns to page. I'll just show.
You are residing in this said house and cultivating.
If they dispute my identity, then I have annexed the identity card also, showing that I'm the son of a Fakir Chowkidar. Page 16, Aadhaar card. Right from page 17, Malad Butchi, it's all our bills, electricity bills, up to 2023, page 17 to 32. Page 17 to 32.
Yes.
Ranjit Chowkidar, 18, Ranjit Chowkidar, all in the name of Ranjit Chowkidar. Water bills, electricity bills are there. And when to see the opposition, I'll just show their stand from their opposition. What I could gather from the opposition is that they say, my lord, my father did not occupy the land. Their plea is, my father was never in occupation of the land.
Unit Council, what is your name?
Ranjit Chowkidar.
In the writ petition?
Ranjit Chowkidar.
Exact name?
Ranjit
RANAJIT. In the document.
He is the affidavit has been affirmed by the power put on holder. I filed the photostat copy of power put on holders. In the Aadhaar card.
In the document at page 20, 21, 22.
They have not raised this point that I'm not that Ranjit Chowkidar in the opposition. Had it been so, Lordship, I could have used my reply. So only I've said, my lord.
Okay.
I've annexed my Aadhaar card. My lord can see that also. Page 16, Aadhaar card, Ranjit Chowkidar, son of late Fakir Chand Chowkidar. So they are free. They are free to take my property, but strictly in accordance with law, in terms of the local regulation. But not in the manner, not kindly see the modus operandi. This is not warranted, at least from the state. I can understand private dispute, one can take my property, I file a suit, those things I know. But state under Article 12, but I have to have certain responsibility which they have to adhere to, particularly when it comes regard to a property. That's my point.
Lordship was right. There are two different persons, Ranjit and Ranjit.
Learned Council, wherein you have mentioned in your affidavit in opposition?
No, it is not mentioned in the document of power of attorney by someone.
Learned Council, that your contention, can it be taken now?
No,
After you have filed the affidavit in opposition?
The honorable court, there are two different persons, Ranjit and Ranjit. Yes.
In which paragraph you have mentioned?
No, I have not mentioned.
Next point. This point cannot be considered. When in spite of filing the affidavit in opposition, you have not raised.
That point we just want to.
Let us.
6 persons. As per the document of power of attorney, page number 40.
Page number 14.
40.
40.
40. One is Ravindran Chowkidar, second is Ranjit Chowkidar, third is Ranjit Chowkidar, and there are total 7 persons.
Oh, there is another person in the name of RANJIT.
Yes. That is only I want to point.
There are two persons. One is
Yes.
RANJIT, one is
Ranjit.
RANAJIT.
Yes.
There are 5 writ petitions pending. Individual writ petitions will be taken out one before my lord. The other is also listed. Some matters are before court number one. But those matters were not taken up yet. So I'm moving the application for the first time. Had I moved that application first, I could have delisted the matter. These are moving for the first time. Just to avoid conflicting decision, had I argued that matter first, then I could have delisted.
All the matters should be tagged up.
This is, amongst these matters, this is the first matter which is before, my lord, I'm arguing for the first time. It's a
All-
fresh hearing.
All matters should have been tagged up.
That's.
Then it will
See,
different
no,
order
why?
will come.
I can show this order to his lordship as and when those matters are taken up. There's no hard and fast rule.
The time of the,
Yes, next.
my lord, or some contention in the affidavit in opposition is that the original recorder tenant have abandoned and it was resumed by the department under section 152 of the regulation.
In which paragraph, in which paragraph?
In the paragraph number 4,
Yes, place the paragraph.
yes. Contention of paragraph is admitted, further submitted that the land bearing such and such had been allotted to Fakir Chand Chaukidar during the year 1958. But the said Fakir Chand Chaukidar did not occupy the said land and also not paid the land revenue for the period of 22 years. And subsequently during the year 1980, the land has been resumed by the competent authority. After the demise of the recorded tenant, his wife, son and daughter had forcefully entered into the land during the year 2003. And resided over the land, and they have raised plantations such as fruit bearing dairies such as the section 152 of the Andaman Nicobar Island Land Revenue Land Reform Regulation 1966. The land of the father of the petitioner were taken by the government, and at present their land bearing survey number 26 such and such has been surrendered for construction of sign, motion, bund such and such. The present status is that subsequently the land record has also been corrected and it is recorded allotted to somebody else. We will produce the.
We are concerned as regards to survey number 26, survey number 27
and 70.
and survey number 70.
This is one point, your lordship. Thereafter, the ground of limitation.
According to you, Fakir had surrendered.
Yes.
The father of the petitioner.
Abandoned.
Surrender is one thing, amendment is another
Yes.
thing.
And
No, what do you intend to submit, Learned Council? Place the paragraph once again.
my lord,
Place the paragraph once again. What do you intend? Abandoned or surrendered?
abandoned and resumed by the authority in the year 1980 itself.
19, survey numbers 26, 27, and 70. Follow hectares as a paddy to home, paddy to restoration. But the said forfeiture did not. But the said forfeiture did not occupy the said land, also not paid the land revenue for the period of 22 years.
My lord.
Subsequently, during the year 1980, the said land had been resumed by the competent authority.
Yes.
So, and after the demise of the recorded tenant and his wife, son and daughter of late Fakir had forcibly entered into the land during the year 2003 and resumed and residing on the land, and they have raised plantations in the said section of land, the land of the father of the petitioner were taken by the government in order to Sri Ananda and 9 others. Why the survey number measuring other surrendered So, and the survey 27 measuring area of 2.11 hectare has been surrendered for construction of sign motion bund for right of way. Survey number 70 measuring area surrendered wide. So,
The petitioners were aware of all the proceedings and they were sleeping for several years. As such, no, why notice it? During the lifetime of his father, it was abandoned.
according to you, no notice was served.
Neither to my father nor to us. They admit our possession of the subject land. In their opposition, they
No
accept.
notice was served upon either the father or to the lead petitioner. So, show the court that notice is incumbent to be served.
Good. It's a civil, Lordship, my lord notes it's a civil right. Lord, if I go with what my other side is saying, that it's an amendment. Again, Lord, at the cost of repetition, Lord, once again, 152 needs to be gone. 152 contemplates that, Lord, 152, Lord would see, it's a small b, then the authority who is vested with the power to hold abandonment. The subdivision officer may, after such inquiry as he may deem necessary, take possession of land, comprise the holding and arrange for its cultivation and upkeep by letting it for a period of on agriculture at a time on behalf of such occupancy tenant, non-occupancy tenant, tenant grants. So this inquiry, they say, Lordship, certain inquiry has been done, that has to be done by subdivision officer. This opposition must contain those things, whether inquiry was done, what are the nature of proceeding, whether that proceeding was in fact under regulation 152 or now simply they are improving the case. That's it. Simply they have annexed the record entry upon which I relied. They have said much thing in the opposition that those pleadings are not backed up with any documents. It's an official act, Lordship. If they said the amendment was taken place, that has to be in consonance with 152. 152 recognized it's a subdivision officer who can do it. Then how could a Tahsildar can hold resumption Lordship in the record entry? Because under the regulation, all the land records are maintained by the Tahsildar. There must be a contemporaneous record, proceedings for the relevant period. And those records must indicate that my father was given a notice. Then I can say that he was sitting over his rights. I cannot assail it. Simply they have said these proceedings taken place. Where are those papers in the opposition on record? There is a dispute with regard to several RC cases. But they are not sure about what has actually happened. In one hand, they say that it's a surrender, it's a case of surrender. If that be the case, then it's a voluntary act. I've shown 153. I have my father have to give surrender it voluntarily by making an application to Tahsildar. Let them show an application, Lord. The surrender in fact was taken place. Then I have no case, I'm out and out.
All disputed facts, my lord,
Now,
it cannot be decided in the writ petition.
Now you cannot take a U-turn. You justify your stand.
Does them show any application that during the lifetime of Fakir Muhammad has made a representation? No representation has been
My
made.
brother is hitting on a very hyper-technical issue. Rights have already been affected.
What you
There
are
judgments of Supreme Court which says
submitting the same thing I am submitting, that they are not also filing any representation.
You had the opportunity.
Yes, madam.
But my saying is, there are Supreme Court judgments which says if a decision is already taken, sending a demand notice would be an idle formality because rights have been already affected. They've already affected my right. My father's name has been said that the property has been resumed. It would remain an idle formality. There are judgments of Supreme Court. And I'm not legally precluded from approaching this court, Lordship, challenging the action of the authorities, the way it has been done in the present case. My property, you're given it, to take it. I'm saying you should take my property, but in terms of the regulation, but not in this way which has been done here. No, I'm possessing. They admit in the opposition. Rightly or wrongly, they say that I have taken forceful possession in the year 2003. That remains I'm in possession, Lordship. Then how could amendment can come into effect? In amendment proceeding, possession has to be taken back. It is to be restored to the government. Records must show it's a government land. If it is given to a third party, their names must be found place in the record entry. Where are those papers? They can't, Lord Mohinder Singh Gill's judgment, Mullah knows. They cannot improve in the opposition. What is there in the adverse decision, that is staring in their face. Don't have given up my right for filing reply because they use the same one document. Had there been some other documents in the opposition, I could have taken the privilege to use my reply to rebut those documents.
Yes. Anything more?
May I submit?
Yes.
Lord, first they have to establish the right. To establish the right, they have to pay land revenue. As per the section 114 of the regulation, the land revenue assessed by the shall be first charge should be paid by the party. They have no right as such, they have not shown any document that they have paid the land revenue. Number one. And
You are referring to?
regulation 114.
At page 21.
Yes, 114.
What?
Land revenue assessed on any land shall be first charged on that land on the crops, rents and profits thereof.
Yes, Your Lordship.
Hmm.
And paragraph in our opposition, paragraph 10, page number 4 of the appearance opposition,
Hmm.
we have said that the server number 26 was has been now allotted to one Ananda and 9 others. While this is RC number 1930/1996. And server number 27 has been surrendered for construction of signed motion bond. This is by the subsequent tenant, which we have enclosed in annexure R2 of our document, page number 8 and 9.
Server number 27 has been surrendered
Yes,
for construction of
it is evidence from the page number 8, the document we have enclosed.
survey number 70 also surrendered.
Yes. No, this is by subsequent tenant.
Hmm?
My lord, page number 8 of the document annexure R2.
No, you were referring to paragraph 4.
Yes, 4 only.
In paragraph
Thus, it was this land has been allotted to Ananda and 9 others. And server number 27 has been surrendered for construction of sign motion bond. 70 has been surrendered for wide RC number 89.
Dated 10/2/1989.
Yes. And connected document is also enclosed, my lord.
Hmm. Hmm.
The document is I have annexed at page number 8.
Yes.
This is the document. And these are server numbers,
You are referring to
page number 8 and 9.
page number 8, which portion?
The server number is mentioned 19/2.
7. Yes, 7. Serial number 7.
26. 27. Serial number 8.
No. Serial number 7, serial number
8.
8.
And serial number 13.
Serial number 13.
Yes. And thereafter, no action has been taken by the any of the no representation is there. And after several years, yes, they have coming up with this writ petition now after 45 years. As such, this writ petition is not maintainable. They have never challenged this order. They were
Here is the order. I don't find
they have
anything in the order.
never raised any claim till now during the lifetime after the death of late Fakir Chowkidar. During his lifetime, he never raised any. That's because he knows that it has been abandoned. Only now, in the year 2003, the petitioners have forcefully occupied the land and residing therein.
When, when your father expired,
I am just giving it there, that's it. No, death certificate, my lord, find at page 35, 28 April 2003.
39.
Yes.
No, it's 28 April 2003. Page 35 of writ petition, next 24.
Page 30.
35. Immediately after the, yes, letter P4, no. Immediately thereafter, immediately thereafter.
Page 39.
I'm so sorry.
Page 39. Fakir Chand Chowkidar. Expired on 20th April 2003. Yes. Anything more to be submitted in this process?
Yes, this is also barred by limitation, and they have never challenged the entries made in the record of right.
Let them show, my lordship, this record entry can be challenged anywhere. I have taken up this writ application, questioning the entire action of the authorities.
After 45 years.
I'm still in possession, lordship. It's a cause of action, is a recurring one, continuing cause of action. They do admit, lordship, in their opposition, I'm in possession. Right here, they have not evicted me. And my lord would see those page 8 and 9. My lord would see at the top. Lord, kindly turn to page 8 and 9 once again of the opposition. At the top, my lord, see, this is for unoccupied land available for disposal. When I'm in occupation of a land, how could they give the land just for the sake of argument? And moreover, not to see serial number 7, 8, and this is serial number 13. All records surrender. I've shown the provision of surrender. Let them show one paper, just one piece of paper. My father surrendered. I take the chair, lordship. I will not add anything on to my submission, lordship. That's my argument.
But Fakir Chand Chowkidar was never in possession. After the death, only is this person in the year 2003. Recently, they have forcefully entered into the possession. That is our stand in the opposition.
Okay. Mr. Bokshi. Acha, acha. Promila Mistry.
Yes.
Hmm. Other matters?
Seven matters. Seven great
But
applications.
first matter is the first, which I've argued.
Hmm.
In no code, the other matters were started. So I have a right.
number.
So that all the matters can be disposed.
No, I have to delist it. If it's under code number one, I have to delist it.
You mention it? You mention it?
No, I'll mention it tomorrow.
Tomorrow you
For
mention it?
inclusion on day after.
On day after tomorrow?
For inclusion, yes.
Let the numbers be provided.
No, tomorrow, on notice only I'll mention it, Ashok. And I'll mention before the order code number one. I'll give a notice to them.
Let the numbers be
Yes.
provided.
That will be clear, sir.
Let the numbers be provided in respect of the remaining five.
Yes.
WPA 228 of 2024 to appear on, to be listed on day after tomorrow on consent of both sides. So learned counsel, both of you have the responsibility to bring the register.
On 16.
On 16th. Day after tomorrow. No, 16th. On 16th. Today is 13th. On 16th. Oh, not day after tomorrow, that is on 16th.
Pleasure.
I got 47, WP to 31. 47, I am appealing for all the respondents, my lord. I have filed my opposition in the cost.
Representing Union of India also?
Yes.
Acha.
On the cost title, the name of Anita Hegde is wrongly mentioned instead of my name. Cost.
Acha. The learned counsel.
Yes, we received one.
Okay, Mr. Bokshi. Nobody is representing the petitioner. Not today.
Oblige, my lord.
Mr. Bokshi, go through the name of the learned counsel. It will be corrected on the next day.
My lord.
48, WP 44.
I am appealing for the respondent, my lord.
Yes. What are you praying? Forty-eight. Number 11.
Because some more time to file reply, my lord.
Opposition has been filed, my lord. They are seeking extension to file reply, my lord.
Item number 49. Number 11.
My lord, I am appearing for the administration, my lord. Coast Guard is also represented.
Coast Guard is represented,
50 and 51.
50, 51 and 52, my lord.
50, 51, and 52.
I am representing the
Andaman and
administration,
Nicobar administration.
but Coast Guard is also there.
represented by Leonard Council Vidi Sobalan.
So both of you are representing the
Yes.
respondents.
Yes, yes.
Who is representing the petitioner?
Petitioner, my lord.
Prashant sir.
Arun Prashant.
Yes.
He was
It's 3:30, it's totally left.
It's 3:30 today. Today.
Today, let's see, 3:30.
Hmm?
So Prashant is here at 3:30.
Is there a resolution to that effect? That
Tally will not.
It's all convention lordship which follow, sometimes 3:30, sometimes 4.
Let it be not today, my lord. Learned
not
advocate.
today.
Yeah, he's requesting for day after tomorrow.
But on consent of on.
No, on that, the request of council appearing for Coast Guard, my lord.
Yes.
Nice.
Yes, for tomorrow.